What's up, guys? Welcome back to Courtroom Clapbacks. On our docket today, we are headed into Judge Springstead's courtroom in Michigan, where Mr. David Rodriguez is being charged with stalking his ex, breaking into her house, beating her with a belt, wrapping the belt around her neck and choking her with it until she thought she was going to die, then sending her threatening text messages about sending her to the morgue. The defense is asking for 36 months a sentence, and prosecutor is asking for a longer sentence, but up to the judge's discretion. Now, this is just a hearing, but the judge is going to go ballistic on this guy. And I'm going to let you guys hear it for yourselves. So buckle up and get ready to go into the courtroom because court is now in session.
Next up is David Ray Rodriguez. It's case number 26-13746FH. We're here for a Cobb's hearing. The court did review the defense memorandum as well as the people's memorandum. And Mr. Prysock, you can go ahead, sir.
Thank you, Judge. Well, we're asking the court to consider the low end of the guidelines for Mr. Rodriguez. I had him at 30. The prosecutor has him at 38. So we're asking the court to consider a 36-month, 38-month sentence on the bottom part of the guidelines. And we'd ask the court to also consider the fact that Mr. Rodriguez, though he had some prior history with the court, his last offense, it looks like, was an operating with intox in 2021, and he had some felony possessions in 2018. Thank you, Judge.
All right, Mr. Walber.
I was at the court score within the guidelines. I laid out my response for the court. I guess what I would direct the court to is OB7, which I thought was scoreable for 50 points. I've met with the victim on this case. This isn't your run-of-the-mill domestic, Your Honor. I thought of the depravity on this was certainly raised to a higher level. I personally think 36 months is too low. The victim asked me what I thought the court would do. I said I thought the court would go somewhere closer to the midpoint. They weren't inclined to do anything. Long criminal record. Like I said, I think I had 55 for the PRV. If I got that corrected, I maxed this out for the OB, Your Honor. I scored 87. I believe a max OB scoring for this is appropriate, and then something within the guidelines, Your Honor.
Well, so at this point, the court could agree to a minimum sentence not to exceed 5 years to a maximum of 20 years. The defendant does have a prior domestic violence, MDOP, most of the time interfering with the telecommunication device or malicious use. Usually that's domestic related, although I don't know that for sure in this case. But so he's got a bad record, but mostly it's the facts of this case. They broke into an ex-girlfriend's apartment allegedly wrapped his, beat her with a belt that somebody would do to an animal, wrapped it around her neck and choked her, knocked her on the floor, grabbed her by her hair, and sent messages that he was going to send her to the morgue, calls her some vile names, doesn't care if she's hurt. And basically, arrested guilty. So that's some pretty egregious conduct under these circumstances. So court could do 5 years.
That's to please the court. So this one. He would accept the Cobb's agreement, judge a 5-year minimum. And if the court pleases, I have police report here from the Michigan State Police. It's one paragraph that I believe would satisfy the elements of the offense. The court would take a no contest plea today for the charge, Judge.
Remember that, Mr. Wilbur?
I have no objection there. I tried to, I'm sure it's the paragraph I cited in my Cobb's for the court, so I have no objection to that.
All right. Wait, is that what you want to do, Mr. Rodriguez?
Yeah, I mean, I was hoping for like a 3-year cap. My dad is in the last 10 years of his life. I mean, I realized the nature of the offenses. I haven't been in trouble in 5 years. I had a job, I had an apartment. I had things going for me. I was a productive person. I paid my job to work, stuff like that. Yeah.
We can take this case to trial.
I don't think it's probably in my best interest.
All right. So you want to plead guilty or no contest to assault with intent to great bodily harm, less than the crime of murder with being an habitual offender third, with agreement from the court that any minimum sentence not exceed 5 years. Raise your right hand, please.
Got it. Just before we get too far, there was an additional piece. I have a additional report I was reviewing from Michigan State Police. I indicated I would not file charges as part of a plea on the spot. I think I brought that up last time. I don't know if I put that in my brief, Your Honor, but it's unrelated to this, but I said I would include anything. There would be no charges.
That's correct, Judge.
Oh, okay. Something about a stalking.
Yep.
But that's not going to get charged.
Correct, Your Honor.
All right. All right. So you solemnly swear oath or affirm that the testimony you're about to give is the truth, whole truth, and nothing but the truth, so help you God?
Yes.
All right. So the charges that you're entering a no contest plea to read as follows: that on or about October 29, 2025, that you were in the city of Grant, Rico County, state of Michigan, and that you did make an assault upon Amy Jo Mishler with the intent to do great bodily harm, less than the crime of murder, or by strangulation or suffocation. This is a felony which carries up to 10 years in prison or a $5,000 fine plus cost. A consecutive sentence may be imposed if the assault is committed in the place of confinement. You understand count 2, the maximum penalty. In exchange for your plea to that, they're dismissing a more serious charge of home invasion, first degree, that carries up to 20 years. Do you understand that? They're also reducing the habitual offender fourth, which had the potential of increasing your maximum penalty to life, but they're reducing that to habitual offender third. You understand that?
Yes.
With the habitual offender third, that could increase your maximum penalty to 20 years. Do you understand that? And the basis for the habitual offender third was the allegation here is that you were convicted on or about May 8, 2018 of controlled substance second offense here in this court. Do you have that prior felony conviction, sir?
Yes.
And also November 10, 2020, possession of cocaine and heroin or another narcotic, again here in this court. Do you have that prior conviction as well? Okay. So in this case, you had a plea offer that would have sentenced you to anywhere within the advisory guidelines, and the prosecutor scored those at 38 to 114. Do you understand that that's what their offer was? The court has entered into an agreement that if your plea of no contest goes through today, that your minimum sentence would not exceed 5 years and the maximum sentence would be 20 years. Do you understand that? Is that your complete understanding of the agreement to resolve this case?
Yes.
Have you had sufficient time to consult with Mr. Prysock about your charges, the plea offer, and the Cobb's agreement that the court entered into today?
Yes.
Subject to the plea agreement and the Cobb's agreement, how do you wish to plead?
No thanks.
Reason for the no contest plea, Mr. Prysock?
Potential civil liability.
All right, the court has found that that's an appropriate reason for offering a no contest plea. So, Mr. Rodriguez, do you understand that with a no contest plea, you're not admitting this charge, but you're no longer denying? Do you understand that?
Yes.
The court's been provided a copy of the police report. And if I find that the elements of the offense are contained therein, I would find you guilty. Do you understand that?
Yes.
It would be on your record. Do you understand that?
Yes.
And you'd be subject to sentencing according to this Cobb's agreement. Do you understand that? You also understand that your no contest plea is accepted, you'd be giving up the right to have a trial of any kind.
Yes.
You also understand that you're giving up the rights that you would have at that trial.
Yes.
You signed a circuit court plea advice and rights form dated today. Did you read that document?
Yes.
Did you understand those rights?
Yes.
Have you gone over those rights with Mr. Prysock?
Yes.
Has anyone threatened you to get you to make this plea? Has anyone promised you an outcome different than was placed on the record?
No.
You're entering this plea of your own free will?
Yes.
Do you understand that if I accept your no contest plea, you're giving up the right to later claim that this plea was not your choice?
Yes.
You now give up your right to have a trial of any kind and all the rights you would have at that trial, and do you still want to plead no contest?
Yes.
All right. All right, so the court has had an opportunity to review that police report, and it essentially was the interview with the victim in this case that indicated that she tried to lock him out of the house. She knew that he was angry with her, but apparently she didn't lock the door or didn't close enough. So he barged in, began yelling at her, beat her with a belt, put the belt around her neck, choked her to the point where she couldn't breathe, thought he was going to kill her, and basically given her his actions, he said, if he's not going to kill me tonight, he will sooner or later. That in conjunction with the other statements from the people's Cobb's and Miranda, the court has found that the elements of the offense are contained in the report. Are the parties aware of any promises, threats, or inducements which have not been stated on the record?
No, Your Honor.
There are none, Judge.
Is he competent to enter this plea?
Yes, Your Honor.
Yes, Judge.
Does the court comply with MCR 6.302?
I have, Your Honor.
Court has.
All right, the court has found the plea to be no understanding, voluntary, and accurate. I'm going to refer him to the probation department for preparation of a pre-sentence investigation report. I will set his sentencing for July 7th at 9 o'clock.
Well, what did you guys think about this guy? What a coward. What an abusive coward. The defense wanted 36 months, but as the judge began to read off these charges, the things that this guy did, all of a sudden the defense was willing to go with 5 years. This judge was not going to take this lightly. It was so egregious, and that's the word the judge used. This is egregious conduct that this guy did. And if these charges were to be sentenced consecutively, this guy would end up in prison for life. He could get a life sentence or 20 years to life. So he is getting off easy if he gets 5 to 20 years, because he's not going to spend 20 years there. Not unless he gets in a lot of trouble there in the jail and they hold him because of that. But what did you guys think about the way the judge is leaning? You think he's going to follow through and give him a harsh sentence? I hope so. You think about so many women right now in this same situation with their abusers, afraid to reach out because they believe that the abuser will kill them if they reach out for help. They believe they'll end up in a morgue. It's just so I believe judges have to take these cases seriously. Have any of you been in this situation? I have a daughter who has been in a situation similar to this one. And like many of abused women, she invited him back again. So these judges have to take these cases seriously. Let me know what you guys think. Drop your comments below, and I will look forward to seeing you right here again on our next case. But for now, court is adjourned.